Hello and welcome to Freebie Council's webinar, How to Protect Your Business and Increase Its Value with Trademarks and Design. My name is Claudia Tapia. I'm the chair of Freebie Council and will be your host today. As you may know, Freebie Council is a non-profit research council developing high-quality academic research on topics related to intellectual property and innovation. This webinar is one of many we are running this year. We also conduct educational activities, including those promoting innovative small and medium enterprises to grow their businesses using intellectual property. Visit our website for a range of free materials. The slides and a recording for this webinar will be available on our website tomorrow. If you have questions for the speakers, please post them in the Q&A area on your screen. We are delighted to run this webinar today in collaboration with INTA, represented here by Helen Nicora, Chief Representative Officer, Europe. Helen, the floor is yours.
Thank you, Claudia, and a warm welcome to you all. Very happy to be joining for IP Council in this webinar today. I'll just take a few minutes to introduce you to INTA, the International Trademark Association, as you may not be familiar with us. So we are a global association of brand owners and professionals dedicated to supporting trademarks and other types of IP rights that you will all hear about in a few minutes, to foster consumer trust, economic growth, and innovation. And what we do is that we organize events. We also advocate for better legislation and practices, and we provide resources to make your life easier in a nutshell when you seek IP protection. In terms of our membership, we have more than 6,500 organizations across 185 countries, so truly international. And we represent more than 500,000 professionals, including brand owners from all sizes of companies. So in-house counsel, so that means the team in charge of IP within the company, from major corporations, but also including SMEs like you. We have also law firms, non-profits, government agency members, professors and law students. And you can find more information on our website, inta.org. And I'm very happy to say that actually today, in honor of the World IP Day, just a reminder, this is World IP Day today. So happy World IP Day. And we will be releasing a special corner on our website dedicated to SMEs, where you can find all types of practical information and tutorials. And I'm very, very delighted that we have actually 3 very committed INTA members participating today in this webinar, but just to flag out that they're not going to provide any legal advice, but they're going to offer their expert opinion and try to answer your questions as much as they can. Claudia, back to you.
Thank you, Helen. Without further delay, please allow me to introduce you today our great speakers, all of whom have roles within the Pro Bono subcommittee of INTA's Brand for a Better Society committee, which will be presented to you at the end of the presentation. Let me start with Kate. Kate O'Rourke is a partner and head of trademarks at Mewburn, Ellis LLP in England. She's a solicitor and chartered trademark attorney with over 25 years' experience in relation to trademarks and related copyright, design, and internet matters. Her work includes advising on the adoption, registration, and enforcement of trademarks international, with a particular focus on the leisure and retail industries. She has a particular expertise in counseling clients on international filing and enforcement strategies and avoiding dilution of the value of trademarks, which we will talk today. Very important points. So Mascha Heidelberg is a junior partner and certified IP lawyer at Müller, Schupfner, and partner in Hamburg, in Germany. She is specializing in trademarks, designs, and unfair competition law. Mascha creates, manages, and consolidates multinational trademark portfolios and develops IP strategies. She conducts availability research, searches and advises on how to avoid or successfully resolve possible office objections or collisions, also by means of the limitation and priority agreement. And finally, Sandra Sophia Redeker is a partner in the IP group at SKW Schwarz and co-managing partner at the firm's Berlin office. With about 20 years experience, she is specialized in trademarks, designs, trade secrets, domain names, unfair competition, and false advertising matters. Her practice is focused on the development, enforcement, and prosecution of worldwide trademark and design portfolios, multi-jurisdictional trademark clearance, borders issues, and anti-counterfeiting measures, multi-jurisdictional trademark clearance, as well as on developing marketing campaigns and merchandising strategies. So I can only say, wow. So Kate, over to you.
Thank you, Claudia. And thank you to 4IP Council and INTA for this opportunity for the three of us to present today, to share our thoughts on protecting the business of SMEs and increasing the value of those businesses with trademarks and designs. I will be providing a brief introduction to IP rights before handing over to Mascha and Sandra for further detail on trademarks and designs, before finishing off at the end with information on an exciting new INTA initiative to provide pro bono advice to SMEs, individuals, charities, and non-profit organizations. So firstly, Axel, next slide. We're often asked as IP attorneys, why should I bother? I don't believe I have any trademark or any other intellectual property rights. People say, why should I invest my money in protecting them? Well, as this slide shows very clearly, IP rights are everywhere. So this particular car might have patents because they've got new brake systems or trademarks, designs, copyright. They might even have confidential information or trade secrets. Everything you look at, I guarantee that Sandra, Mascha, and I can find you some IP rights. And the thing is that protecting your IP rights has been shown to help secure a profitable future for your business. In our experience, when you come to sell your business, if you ever want to, the first thing that you'll be asked to produce is a list of your IP rights. Now, on the next slide, you can see that there are loads of kinds of intellectual property rights that you can secure without registration. So absolutely created automatically. As I mentioned, confidential information or trade secrets, the most famous, of course, being the recipe for the Coca-Cola drink. Copyright doesn't need to be registered, and there are also there's protection given for unregistered design rights and unregistered trademark rights. However, some rights do need action in order for them to be registered. So on the next slide, you can see I've listed the types of registration that you can secure. So here we're focusing, well, I've listed here registered trademarks, registered designs and patents. But for today, we're going to be focusing on trademarks and designs. And for more detail about those, I'm now going to hand over to Sandra and Mascha.
Thank you, Kate. Next, please. Thanks. Before we give you a couple of more details on registered designs and trademarks, so just a quick overview on the four more important IP rights. On the left-hand side of the slide, you see patents on in the first row. Patents protect actually technical inventions, to describe it in a rough way. So it's how something works. It must be new. It's only if it's new, it can be protected, and it has a maximum protection period of 20 years. Registered designs are different from patents. While patents protect the technical side, designs protect the side how it looks like and whether it's new and original or individual. And we're going to dive into that a little bit more deeper in a few minutes. And in the same way as with the patent, it has a maximum period of protection, and it can be, at least in Europe, 25 years. In other countries, it can be less. Over to Mascha.
So, registered trademarks, the main aim is to signal the origin of production to consumers. So you want the people who see your trademark that they know that it's your company. So we dive deeper into this in a second. Just one thing about copyright. So what you really need to know is that it actually happens automatically. The minute you get something into a fixed form, even if that fixed form is just a pen scratch on a legal pad, you automatically own the copyright to any creative work of art you produce the minute you produce it. But keep in mind, just having an idea how you would produce things or what you want to do is not enough. It has to be fixed. So on the next slide, we will see, so today's focus are trademarks and designs. I will start with the trademarks and then hand back to Sandra for more details on the designs. On the next slide, we are talking about functions of the trademark. So the most important thing of a trademark is that it identifies the product and its origin. It proposes to guarantee its quality, and it advertises the product. So the trademark represents your product. The trademark is supposed to create an image of the product in the mind of the public, particularly of the consumers or the prospective consumers of such goods. So, and with that, you create trust on your products. So it means that, for example, when it comes to quality control or safety requirements, when you have things like safety belts, you just show your customers that there will be quality control, that you will take care of all the safety requirements compared to, for example, counterfeits. Or in pharmaceuticals, you just want to show that there are no dangerous ingredients or substances in it. So take your trademark and produce your value and identity to the customer. On the next slide, we are talking about the trademark definition. What is a trademark? So we just picked the one from the European Union, but they are all over Europe quite similar. A trademark may consist of any signs, in particular words, including personal names, or designs, letters, numbers, colors, the shape of goods or the packaging of goods or sounds, provided that such signs are capable of distinguishing the goods and services of one undertaking from those of another undertaking. That means in trademarks, the goods and services are grouped in classes. So you have a registration in which the goods and services are grouped within the lease classification. Each class, we have 45 classes, and each class contains a class heading and explanation, with a hint helping you to categorize your goods and services. And if you need help, well, go to your IP attorney. They will help you to classify all the goods and services which might be in the list or are not, and then create the list of goods and services for you. Second thing is your trademark needs to be distinctive and must not describe what you sell to be eligible for registration. So there are fanciful and arbitrary trademarks, suggestive trademarks, as well as descriptive and generic trademarks. For that, if you are interested in more detail, just come back to me in the Q&A and we can give you more details on these distinctions. On the next slide, we are talking about types and forms of trademarks. What is the second part of the definition under B? Being represented on the register is a manner which enables the competent authorities and the public to determine the clear and precise subject matter of the protection afforded to its proprietors. So whatever you have, there must be a possibility to put it into the register. So everybody knows word trademarks, we have figurative trademarks or combinations of it. Slogans, everyone knows just do it from Nike or I'm loving it from McDonald's. So we have that. Then shape, we have shape trademarks. We had Coca-Cola again. So everybody knows this very specific Coca-Cola bottle, which is a shape trademark. Who likes more chocolate? Ritter Sport just got a trademark on chocolate, on its specific chocolate bar. Nevertheless, that's easy. But what about sounds and smell, which is much more difficult to get registered? For sound, you can have the notes as we have them on the slides, or by now just submit an MP3 file. So that should be easy, but still it has to be a trademark. It should be trademarked, and it's not just like a sound where you want to dance to. So for example, Zippo, the American lighter company, secured a trademark for the click when you open it, and they describe it as the sound consists of the sounds of a wind-proof lighter opening, igniting, and closing. It is registered as a trademark, so it does work. So same as with smell. Smell is difficult. How you want to protect a smell? So you can't just submit a pattern because the scent just flies away. But Play-Doh, everybody of you who has children who like to play with modeling clay might know them. And they actually have a registered smell. And I have to cite this: sweet, slightly musky, vanilla fragrance, the slight overtones of sherry, combined with the smell of a salted wheat-based dough. This is a smell registration, which is very interesting. So, but you really have to be very convincing, and sometimes actually have used it for a long time to get this registration. So with that, I pass on back to Sandra for the designs.
Thank you, Mascha. Some creations, some creations can be either registered as a trademark as well as a design. So it might be sensible to look into your IP a little bit more deeper once you start to think about what to register exactly, especially if you have a logo or if you have something which is drawn, or a shape of a product, as Mascha already mentioned. It might be better to protect it as a design or protect it as a trademark, or sometimes both. It depends on your budget and how deep your pockets are, and it depends on how fast moving the business area is where you actually act. So in registered designs, or designs as such, coexist with trademarks, and they can be an alternative IP right, or they can be a cumulative IP right. What is a design? A design is everything which is a 2- or 3-dimensional creation. And as outlined here on the slide, it can be a part of it, or it can be in the whole of a product or creation, resulting from the features of lines, contours, colors, shape, texture, material, whatever. It must be new, so it must be new, and actually it must be new on the EU market, but actually worldwide. And it's not, this is a big advantage of design, but it does not depend on any goods and services. So when a design is registered, it is registered as such, and not in relation to certain goods and services. Next slide, please. Yes, here you see an overview on the different, a selection of the different forms and types. You have, like in the clothing area, you have hundreds and thousands of designs, some of them registered, some of them not registered because they have 2 or 3 collections per year. So it's not worthwhile to even register them, but they might be protected as an unregistered community design within the EU at least. Jewelry is one scope of protection, for example, as well as patterns. So this is often used in the fashion industry. But logos, for example, can be protected as a design as well as a trademark. Same applies to packaging. And with respect to the technical designs, if a feature has solely a technical function, it's not suitable to be registered as a design. But most technical products can be created in this way or in that way. And if there is a choice how to reach a technical function in through different design, then the design can be registerable. But also buildings, entire products, or figurines and stuff like that can be registered. Next slide, please. Yes. So this was just a very brief overview on registered design, and if you are more interested in designs, we can answer your questions in the Q&A session. But what we would like to stress is, if you think about IP rights, and especially if you think of trademarks versus design, this is the first question you have to ask yourself: what do I need? What product do I have? What company do I have? What's the name of my company? What's my branding? What do I need to protect? Do I need to protect it in unlimited in time, or is a certain period of protection sufficient for me? These are all questions you have to ask yourself and evaluate with together, perhaps with your IP attorney. Then don't register before you clear rights, or don't even use before you clear rights, because it might be more expensive, and it usually becomes more expensive if you use and if you infringe third parties' rights, because you will receive a warning letter maybe, and damage claims and stuff like that. So especially for a startup, that can throw you back in your business and put serious restraints on your budget. If you think of the logo, for example, versus the name of the company, for example, which you want to protect as a trademark, you have to ask yourself, what do I need? Is it a word mark or is it a logo? Will I be flexible in how I use my brand? Do I want to be able to change colors in the future? Stuff like that needs to be explored before you actually file the trademark. And Mascha mentioned it already. If we talk about trademark protection, we always talk about goods and services, because trademark is not registered without any relation to goods and services. And these have an impact on your budget as well, because it's very easy. The broader you want to protect your IP, the more expensive it gets. So you have to ask yourself, okay, where I want to be, where's my company sourcing the business from? Where am I active? Is it national? Is it EU-wide? Is it international? Where is my need for protection? And the broader you get, the more expensive it gets as well. Next slide, please. And yes. And once you have a trademark registered, then actually you're not done. You can lose your trademark if you don't use it. There's a certain grace period of use. In Europe, it's 5 years, but in Asian countries, it's less. It's 3 years in China, for example. You have to maintain usage of the trademark. And we can dive into that a little bit more in the Q&A session as well. Of course, you should enforce it, because otherwise it's somehow useless to have it in the register, because you want to distinguish yourself from competitors. And if they copycat your product or your trademark or the design, and you do not act against it, the market gets diluted. And your competitors may ride on the designs you have actually invented. And you may want to establish trademark monitoring structures, which is less expensive than you may think. And especially in the fast-moving consumer goods area, it might be useful to establish a customs application at the certain borders in order to prevent counterfeiting products from the EU market. And I give over, I think, to Kate for the next slide. And yes, and Kate will introduce the INTA Pro Bono Clearinghouse for the next couple of minutes.
Thank you, Sandra. And as was announced at the beginning, Mascha, Sandra and I are all members of INTA, and we've all been involved with the Pro Bono Committee and the Clearinghouse. Now, the Clearinghouse, as you can see on the next slide, is the means by which we match INTA attorney members who are acting on a pro bono basis, so for free, with the needs of low-income clients. And that includes SMEs, not-for-profits, non-profits, or charitable organizations. It is, however, only limited to trademark-related pro bono cases. On the next slide, you can see why some of us want to do this. We do want to give back to the community. We love our work, but we appreciate that there are a number of organizations and individuals who can't afford to pay for the specialized IP services. And so INTA has brought together a whole team of volunteers who want to actually provide services in the IP field, particularly the trademark field, on a pro bono basis. And it is all over the world. Next slide, please. So as I've listed, that's the eligibility. And then I want to go straight on to the next slide, which is about a very exciting initiative that we're having on the 15th of June. We're having our very first international virtual legal clinic. And this will be designed just like an online walk-in clinic. And applicants from anywhere in the world will be able to consult with volunteer trademark attorneys on an individual basis. The attorneys will be there to answer any of your legal questions related to trademarks, of course, and explain the trademark registration process, and will also be able to direct you to local services if we can't help you on the day. It's a 1-hour clinic, and we anticipate that there will be a lot of interest in this from all over the world. But if you're interested, please do contact our INTA liaison person, Stacey Sutton, and her email is there on the slide. So ssutton@inta.org. It's really exciting for us because it's a completely international event. There'll be attorneys matched with applicants all over the world. And after today's presentation, if you have further questions and if you would like further advice, then please do sign up for the clinic. So I think on my final slide, I just wanted to say this is where you can learn more about INTA's Pro Bono Clearinghouse. And I'm very happy to answer any questions about that and the clinic. But for now, I'd like to pass back to Claudia, because I think she has quite a few other questions that have already been asked in response to today's presentation. So thank you very much.
Thank you, Kate. And thanks to all of you. It's an amazing initiative. Congratulations for it. I hope you get a lot of people writing to you. And also for these taking the time to come to us and share with the rest all your knowledge. I've been receiving some questions in the meantime you were speaking. Some of them were general, some of them were being asked to each of you. So I'm gonna start with you, Kate, if it's okay, which goes into the question, how does the Brexit affect my existing trademarks? And what does it mean for my trademark filing strategy?
Thanks, Claudia. Brexit is my specialty subject. I lead the UK organisation's task force on Brexit. So I have lived and breathed this since that day in 2016 where the UK decided to leave the EU, very disappointingly, in my opinion. But anyhow, enough about the politics and over to the intellectual property. Basically, what it means is that instead of being able to get a pan-EU right for trademarks and designs, you now have to get separate UK rights. So unfortunately, 2 registrations are required if you do want to get a registration for a trademark or a design that covers both the UK and all of the 26 countries of the EU. That's the primary initial difficulty. And then, of course, that affects your filing strategy. But then if you want to enforce your rights, you also need to enforce them separately now in the UK and the EU. So unfortunately for SMEs, and in fact for all other businesses, the work has doubled, which is one of the unfortunate side effects of Brexit.
Thank you, Kate. And indeed, unfortunate. I have here another question for Mascha, which says, you've talked about distinctive trademarks and mentioned that there are different types of trademarks as fanciful, suggestive, descriptive. Can you give some more details on that, please?
Sure. Thank you. Yeah, so as I mentioned during the presentation, to get your trademark registered, it needs to be distinctive. And we have this 5 types of trademarks: fanciful, arbitrary, suggestive, descriptive, and generic. And well, if you have a fanciful trademark, this means it's just inherently distinctive. So it's a comprised term which just has been invented for this sole purpose, for this trademark to have this, to have this function to relate to this specific product or service. So it's a new word which is not known, and this is the easiest to get registered, but probably also the most difficult to find, actually. So fanciful trademarks. Then the arbitrary trademarks are those which actually have no meaning, but it's not related to the product sold. So the best example and most famous example obviously is Apple. So I guess it's clear that you don't get the term Apple registered for apples or fruits, but as we all very well know, it is very successfully registered and used as a trademark for electronic products, especially cell phones and everything. So that's an arbitrary mark, so it's a known meaning, but just used for something completely different. Suggestive trademarks maybe are the most difficult ones. So it is a trademark or a term where you hint or suggest what this product or service could be about without actually really say it in a directly descriptive way. So you just try to imply qualities of the product, but still to be seen as a suggestive trademark and not as a descriptive trademark, which comes afterwards. The consumer still needs to have this little situation, say, now I know what they are talking about. So it just needs some imagination what it is supposed to be, and examples would be for Airbus for airplanes, which we all might know, and my favorite actually is Speedy Bake for a frozen dough, which you kind of have an idea without saying it directly. Descriptive trademarks are easy. These are just terms which are just for merchandise, just terms you have in the universal language, everybody knows. They are just not registerable, or when you just have a term which just says, oh, my product is really very good, and trying to give it some quality input, it's not possible to get it registered. But you might overcome this if you just put in a logo or a distinctive company name, and then you have a combined trademark, and then it might work in specific cases. Generic trademarks, well, it's trademarks like food for food, restaurants for restaurants, or like really just saying what it is. And obviously this is not registerable because you don't want having a trademark restaurant on the market and the other restaurant next door is not allowed to use it. So it doesn't make sense. And it's not directly originating to a specific company. It's just a word and a generic term. But on the other hand, there are trademarks which can become generic. So you really have to be careful that you, when you have a trademark which is used very widely, to still keep it as a trademark. So it happened in the US to aspirin. Aspirin is not a trademark anymore in the US. When you say in the US you want to have an aspirin, it could be any pill which is helping for your headache, if it's ibuprofen or paracetamol or whatever. And so it's very rarely, but it does happen. So just be sure to use your trademark as a trademark and not as a generic term.
Thank you. Very clear. Thanks so much. We have here one question. I wonder, Sandra, maybe you want to give it a go. The case is the following. Somebody already has the same trademark I wish to have, but for another product. Can I still file it?
And my most favorite answer is, it depends. So yeah, it depends. Usually, if the product is a similar product or a rather identical product even, and the other trademark is used for the same product range, then I would not really advise to actually use and file a trademark. But sometimes, and we see that very often, if, for example, a trademark is registered for cars and I want to use a similar or an identical sign for chemical products, for example, or for entertainment, for example, and the other trademark, the earlier trademark, is not a trademark with a reputation, because then the rules are different, and that's why I'm saying it depends. So if it's completely different products or services, then the identity or similarity of the trademark doesn't harm, then I might be free to use it. But if the other trademark is a well-known trademark or a trademark with higher distinctiveness, it's very well known in the market, then the rules are different, because then the scope of protection of the trademark is broader, and it covers also dissimilar products or services. So if I have created a trademark, or actually created a brand which I wanted to get registered as a trademark and use it, and I know already that there's someone out there in the market who's using a identical or similar trademark but for certain products, I should get in contact with an IP attorney to actually get advice. This is the classical situation we have to assess usually.
Thank you. Thank you very much, Sandra. Kate, back to you. Is it better to file the trademark in black and white or in color?
Whoa, I'm going to go with Sandra's "it depends" now. I always advise people to apply to register the trademark that they use. So if they're using their trademark in a very distinctive set of colors, then I would absolutely recommend that they file in that color range. However, it does get complicated, because in some countries, like the UK, if you register in black and white, then that won't necessarily cover you if you use your mark in colors, where in other countries, registering black and white covers your use in all colors. So it is, again, one of those moments when you do need the advice of a local IP attorney. But for me, it always comes down to, what are you going to use? And even if you're going to use a range of different colors, which one are you going to use the most? And most clients do seem to appreciate that once you ask them, they have a very clear idea whether or not they may always be looking to use their trademark in black and white, or whether that particular color of, I don't know, is the 4IP Council color magenta. That's what you want people to recognize, and so therefore that's what you want to register, because you don't want people to be using a similar set of numbers and letters to 4IP that may not be identical, but if people saw them in the same color circle, then they might have an association with 4IP Council, and therefore that would lead to confusion, and it might affect your reputation. So going back to the "it depends" question or answer.
It's a very lawyer answer, but that shows also it's not always easy as it seems. Let me go back to maybe Mascha. What is better, a bold trademark or a logo trademark?
Well, I guess we also need the attorney's answer. It depends, and it's a little similar to what Kate just said. So what are you actually want to use? Do you intend more to use the word element as a trademark and put this on everything in red and green and one logo, another logo, or just some style elements? Or do you really have like a logo trademark where you say, I always want to use this specific ornament or picture always together with the trademark? Then it might make sense to actually use this logo or this combination trademark. This is one point. The other one is with the word trademark, you are more flexible if you actually want to use it also as a word trademark. So you can combine it with different things. When you have a logo trademark or a combined trademark, you can just use it, or you can use it as you want, but it is registered and protected only in this very specific combination as you see it. So you look into the register and see, okay, this is what it is like, and this is registered. You can't split things and say, okay, now I have a logo here and there's my word element here, and oh, I have now 2 or 3 trademarks. No, it's just the one in this combination. So if the term seems to be more descriptive, maybe more or less suggestive, it might make sense to have the combined logo trademark or a combination combined trademark, just to be sure. And otherwise, it might make sense to have the word trademark. And what I usually do, especially with bigger size or bigger clients, if you really want to use both, register both, especially if it's not like for hundreds of countries, but just like a European trademark. Your term, for what you pay is just is for 10 years, so it's not so much money, but then you are just on the safe side.
Makes sense. Thank you so much. Sandra, this seems to be for you. I would like to file a trademark worldwide. What can I do and what does it cost?
Worldwide, yes, we hear that question very often raised by very ambitious startups who are positive to actually conquer the world, and they're right in it, but there is no worldwide protection. The world is split in territories, and a couple of territories can be registered as an entire region, like the EU, but there is also in Asian, in Africa, there is a certain region which can be covered by one trademark application, but usually the countries are split into, like the territories are split in country by country, and the more territories you want to cover, the more expensive it gets. And actually there is no cost budget. There is no such deep pockets. Even big companies file for trademark registrations step by step. So what I always advise is, what's your actual business? Cover these territories first. What's your 3 years plan for expanding the business? What's your 5 years plan for expanding the business? And in 5 years, because the grace period of use is for 5 years, in 5 years you might actually reevaluate and then seek for broader protection with respect to territories. So I would always advise that you take it step by step, that you be rather optimistic than pessimistic. So be a little bit broader than you might. So take your best business case and not your worst business case for evaluating on the territorial scope of protection you need. But take it easy and take it better, step by step, because then it's also good for the budget. For example, if you have a company in Germany, because I'm a German attorney, so if you're a company in Germany and you think, yeah, at the moment we are actually only active in Germany, but we plan to expand to Austria and then maybe to Switzerland, because that's the typical German-speaking countries. Maybe then France might be an option, Italy and Spain, and also the UK is very interesting market for us. Then I would always advise, take a German trademark and then on the basis of the German trademark expand the protection. Perhaps even within the first half year, then you save the priority of the German registration. That's all. Some features you can discuss with the attorney. But as said, there is no general budget and answer to the cost issue. So it needs to be discussed, and then the strategy needs to be pursued, which fits the most to the budget and the business plan at the same time.
Makes absolutely sense, I have to say. Kate, if I have a registered trademark in the EU, can I stop businesses from importing products that are the same as my trademark?
Thanks, Claudia. This question actually also has a bit of a Brexit characteristic. So, I mean, the answer is yes. If you have an EU trademark registration, then you can prevent what we call parallel imports into the EU from anywhere else in the world. If those products are branded with a trademark that is identical or confusingly similar to your own. It's one of the great benefits of having a registered trademark. And you can even register the trademark at customs, and therefore the customs may notify you if they notice that someone is trying to import products branded with the identical trademark or very similar trademark into the EU. So as I say, one of the great advantages. Interestingly, ever since the end of the Brexit transition period at the end of last year, we have a bit of a hybrid system between the EU and the UK, and that is that the UK government decided that if you put a product, because we used to be part of this whole EU-wide system, and the UK government decided that it was in the best interests of business that if you put a product onto the market with a trademark in any of the EEA countries, so that's not just the EU, but it's also Norway, Iceland, and Liechtenstein as well, because that's the EEA market, then the UK would treat that as having been use, and you would be able to import those products into the UK, even though we're no longer a part of the old system. However, these days, if you are in the EEA and you have an EU trademark registration, you may be able to prevent product coming in to the market, not only from other countries, but also the United Kingdom. So if there's a situation where you might have split ownership, and we're certainly aware that there is some split ownership of products, even Schweppes, between UK and Spain, now there's a situation where someone sitting on an EU trademark registration could well stop products coming in from the UK. So that's not so good for us sitting here in the United Kingdom, but we were the ones that voted for it. So that's the consequence of that particular vote. So I hope that answers the question.
Thanks, Kate. Kate taking the blame for the vote. So, Mascha, what kind of pictures do I need for a design registration compared to a figurative trademark?
Okay, let's start with the second part. So for figurative trademark, it's just like the logo. It's just what you put on your product. That is a figurative trademark. When it comes to designs, you also, as Sandra mentioned before, it could be a logo as well, but designs are more. So usually when you think about a design registration, you think about a product, a design of a specific product, and then the design is that specific product, like a chair, for example. And then you have the possibility with this design registration to submit different pictures, which mean it is the very same chair, and you can have, for example, photographs from upside, from bottom, from left and right, so from every side. And but it doesn't have it doesn't have to be photographed. It also could be a graphic representation, or when you have these computer programs where you can just like have a screenshot from different sides. It could be something like that. The thing is that you just have to be sure to always really have this one and the same design. Like, for example, if you have a chair and you want to register as in red, green, blue, and white, these are different designs. So they are collective designs, so that's fine. But for this one specific product, it has to be in the same color. It has to be the exact same product, which can be from different parts or from different views. But it's the product itself and not just the logo. So I hope that answers the question.
Definitely. Thanks, Mascha. Sandra, someone writes the following. I don't have the budget for trademark registrations. Can't I just use my brand trademark without registration and save the money for marketing? Or is there any downside that I'm not considering?
There's a clear downside. It's always some it's also something which needs to be discussed with, especially if there's a startup. So there is a clear downside actually. If you use your trademark and you have put money into the branding and then start using the trademark in the market, and as explained during the presentation, the trademark shall indicate the source of origin. It shall distinguish you from the competitors. So it's actually the factor which sells your product. So you invest money into the marketing, into the branding, and then you don't register the trademark. Someone comes along, likes your branding, copies it, gets himself a registration in the trademark registry, and can enforce his trademark against your used trademark, because you might not have an unregistered right, depending on the national legislation. So if the trademark is not at the same time, for example, your company name, which might be subject of an unregistered designation right, for example, under German law or in other national laws. So imagine there's no unregistered right you can rely on. You might lose this trademark, and then you have invested, or you might lose your brand because you don't have a trademark. So you have invested money in all the creation of the brand and the branding and the marketing, and then your money goes out of the roof because you have not spent the basic money to actually protect the trademark. So always register to be on the safe side, and register step by step with respect to territories and classes and so on, to actually save some budget and maybe, put it in the next, collect more money and then spend it on better protection, but do always basic protection.
A very important point, so thanks for raising it. Kate, are the rules concerning trademarks the same throughout the world?
Well, I've been very lucky in my lifetime because I've worked in Australia, America, and now in the United Kingdom. And in fact, I can say from personal experience that the rules are very similar in most countries of the world. There have been international treaties dating back to the 19th century, which have set down the basic rules and regulations that most countries do follow. And interestingly, I think the strength of the European Union has led to a lot of countries following the rules and regulations that have been devised by the European Union over the years. So we're seeing much more of a harmonized system across the world. And the other element that has meant that most countries are fairly well harmonized, particularly in relation to trademarks, more so than designs, is because we have the International Trademark Registration System. And that's the system where if you've got your own home registration, say in Germany or the UK, then you can apply to the World Intellectual Property Organization in Geneva to extend the protection to other countries. And so those other countries have to sign up for a basic level of the same type of harmonized rules. So that has also meant that we're seeing a system across the world which is closer together than it ever has been in history, I think. And that's great, not just for IP attorneys, but it's great for businesses because they can understand what goes on in one country may well be the same in another country, and it also reduces the cost of advising across the world. So I can't say that the rules are all the same across all of the world, but the basic principles are there and are followed by, I would say, 95% of countries, and certainly the countries that SMEs are most likely to want to seek protection and export to.
Okay, thanks. Mascha, let's imagine a company wants to modernize, and what they do is they would like to have slight changes on the logo. Can they change that in the registration and then add some goods to the existing registration?
Good question. No, more or less, no. So when you have a registration, at the moment you file the application for your trademark. That's what you apply for. So there's no amending and getting more. You always can reduce your list of goods. So due to negotiations with competitors, or after a couple of years, you realize you don't need them anymore, you don't use your trademark for it. So it's always possible to get less on the goods and services side, but you can't get more. So that means if you extend your business and say, oh, I now need more goods and services, it actually would be a second completely new application for this trademark. Well, the thing with the modernizing or slight changes of a logo, it's a tricky question, which actually I don't want to say it depends again, but it will be a case-by-case decision at the end of the day, because it really, okay, I don't want to use depend. I have to. It depends.
All right.
It really depends if these changes are only like having the lines a little different, or if the colors are different. If you really don't want to use the old one anymore at all. So usually I would say if there are changes which you can see and recognize, even if you don't have both trademarks directly next to each other, usually I would say file a new trademark. There might be difference or other reasons not to do it, but usually as a red line, it would be a new application as well.
Thank you, Mascha. And Sandra, someone has reacted to one of your statements, and we understand there might be no perfect strategy and everything has risks or not, but maybe you have an idea on this element. What I mean is the following. Here, the point raised is that, yes, it's true that if you go step-by-step registration, it's good for the budget. But here, this participant argues when you want to expand to a specific country, non-EU country, you can find that some other company just register it. And you have to make an opposition, which is very difficult to prove that it has been done with bad faith, that the trademark is already a well-known trademark in such country, or even worldwide. Which are the possible solutions to this case in order to have the trademark register retrieved and used in such country?
Yes, I read it. Thank you. I read it at the Q&A, and actually I already prepared to answer that question. It's not, there's no easy answer. So it depends on the situation. Like if you start using a trademark, and that's what I explained before, think early about potential territories. Ideally, you avoid a situation like that by broadening the protection from the beginning. For example, if you think of EU, you please think also of Switzerland, think of the EEA countries. Will be Norway relevant? Will be Liechtenstein relevant for me and Switzerland? So this is some standard, and UK of course by now, because UK is not anymore covered by the EU mark. So this is would be a standard procedure for me in the very beginning, when it's, even though the business might be a national business, still if there are expansion plans in the next couple of years, protect the territory, cover those territories as soon as possible to actually avoid exactly that situation. If the situation has occurred, it will be difficult. I say it very frankly, and we had situations like that where we were not able to get the situation solved, and the brand owner was forced to actually enter, for example, American company with a US trademark wanted to enter the EU market. And there was obviously, from my understanding, some trademark registered in bad faith, but the bad faith regulations in Germany are very strict. It's very hard to prove bad faith. And so we were not able to actually get the trademark back. And so the brand owner had to enter the EU market under a different trademark because the registry was blocked. So if you, a possible solution might be unregistered rights. It depends on the situation as well. If, according to national laws, the trademark is reflecting the company name, for example, or the company logo used on all the business papers and stuff like that, you might be able to prove an earlier right in the specific country. But if it's a pure product trademark and you cannot prove reputation and you cannot prove bad faith, yep, you have to think about, then you have to think about plan B, which is why it's better to spend a little bit higher budget on broader territorial protection in the first step, than being a little bit too late at the very end and exactly face those situations which will become very expensive.
Indeed. Thank you so much, Kate, Mascha, Sandra, Helen. And also thank you all for attending this webinar and being so active in the Q&A part. Later on today, you will receive an email inviting you to complete a 1-minute survey about this webinar. And we will be very grateful for your feedback. As explained before, a recording of this presentation will be made available for AP Council's website tomorrow. And please visit our website to register for our forthcoming webinars. And with that, I wish you all a wonderful week. Bye-bye.
Bye.
Bye, thank you.